So our final speaker for this morning's session is Heather Morrison. And Heather is an assistant professor in the School of Information Studies at the University of Ottawa. Her background includes extensive experience in academic libraries and a senior coordinating role in the Provincial Library Consortia, focusing on post-secondary libraries in British Columbia and Alberta. As an activist in information policy, Heather participates in national and international policy consultations, such as the process leading to the policy on access to research outputs developed by the Canadian Institutes of Health Research. More recently, she's been involved in the UK's consultations on the latest open access policy with the Research Councils in the UK. She's the author of Scholarly Communication for Librarians, published in 2009, and also the author of the thought-provoking blog, The Imaginary Journal of Poetic Economics.
Thank you very much, Tim, and thank you very much to Allen Press for inviting me to speak on this important topic and to speak with my co-panelists. And one of the points that I want to make is that there has been an apparent consensus on the idea of open access and being CC BY, as my co-speakers have talked about. But what I'm suggesting is that it is time to open up that conversation about what open access and copyright, how they can work together, and what is really best for both the publishers, scholars, and also for open access itself. Just an overview of what I'm talking about. Many open access advocates equate open access with the CC BY license. My argument is that this is not a good idea for open access itself. I want to talk a bit about the blanket downstream commercial rights with CC BY, blanket remix and tweak rights, and present some alternatives. I'll touch a little bit on the moral rights. I think that's something we need to pay attention to, but I haven't really had time to go into that analysis yet. My current research project is called Sustaining the Knowledge Commons. So what am I thinking about for Knowledge Commons? It's derived from open access, but it's something more. The idea that the collective knowledge of humankind should be there for any of us to draw from free of charge, and for anybody who is qualified to contribute to as well. At the core of the center is the public interest and the collective knowledge itself. I have come through my analysis of Creative Commons and open access licensing to think that the so-called BBB definition of open access, which Scott showed us, is in fact a problem, and I don't use it anymore. I'm now using this short definition of open access of Peter Suber's, that open access literature is digital, online, free of charge, and free of most copyright and licensing restrictions. Michael has given us a really good overview of Creative Commons, and I appreciate the work that the Creative Commons has done over the years, providing a suite of licenses that anyone can go and create a license to say, I'd like to be able to share my work and not have the automatic copyright that I get under Byrne, which many people have no clue that they actually have. So what is the Creative Commons Attribution Only license? This is the brief description from the Creative Commons license website. This license lets people distribute, remix, tweak, and build upon your work, even commercially, as long as they give you credit for the original creation. For the casual user, you're uploading your flower pictures to Flickr, the brief description is probably enough. If, however, you are creating a default policy for your journal or your publishing organization or your research funder, you should probably look through and really think about the legal code that goes behind it, because they don't necessarily work together in exactly the way that might seem obvious to those of us who are not lawyers, and I'm not a lawyer. So even commercially, what does this mean, and what are the possible implications for scholarly works? One thing that is important to understand about open access and Creative Commons is that open access works are free of charge by definition. Creative Commons, however, has a lot in common with open access, but Creative Commons works don't necessarily have to be free of charge. One way to think about this is that there are many different communities that use the Creative Commons licenses. It's not just scholarly journals and publishers and authors. It's also people who create music, art, photographs, video games. So why does this matter? It's important to understand if you're releasing your work under a CC license that allows commercial use, that the downstream users can charge for their use. It's not necessarily commercial, but it's free like some kinds of advertising. One of the arguments that this can't be done that I hear is, well, you can't legally put technological protection measures into a CC licensed work that prevent the use. That is true, however, you can put up a paywall that people have to go through in order to get to the work, and there's no getting around this because most of us have to go through a paywall to get to anything on the internet. The licensor cannot revoke the license for the work, that's true, but the catch here is you have to have a copy of the work with that CC BY license in order to exercise your rights. And even here, the licensor does have moral rights. My argument, and maybe it is just me, I'm not claiming any consensus, I'm not sure that anybody in the entire world agrees with me, but I'm asking the open access movement to consider whether pushing for CC BY as a default might be a major strategic error for the open access movement. Why? By permitting downstream total access, if CC BY as a default is a huge success, that could lead to massive failure. How so? Because if someone is selling your work downstream, that does not necessarily mean that the original is going to remain there and be freely accessible. Maybe Public Library of Science is extremely optimistic, they will be there forever, the open access model will work for them forever. However, they have commercial rights like everyone else, and any open access publisher that finds the OA model doesn't work for them has the right to change their business model to toll access, to sell their business to another publisher who likes to use toll access. So in the medium to long term, I don't think we can make any assumptions about all that open access stuff necessarily being there, still being free, still being available under that license. There is, scholarly publishing is both a quasi-gift economy and a multi-billion-dollar-a-year industry in which there are some big commercial players, probably not the people here in this room, who are making profits in the 30 to 40% profit range, millions of dollars a year. In the case of Elsevier, over $1 billion. There will be a temptation to enclose this stuff to gain commercial rights, to gain profits, and I don't think that it's wise to think that that's going to go away anytime soon. The danger is not with the article or two. Okay, you're not going to make big bucks enclosing one PLOS article, one book. The danger comes, what if all the articles in those more than 10,000 journals listed in DOAJ have CC BY licenses? What if everything in PubMed Central has CC BY licenses? That's where someone can take the entire corpus, copy it, and sell it, and that's where that temptation I see coming in. Maybe I'm wrong, but I think we should at least think about this and talk about it and see if there's remedies. The remedy for me, number one for the OpenA movement, abandon CC BY as a default. Quit trying to push people to use this license. Copy the works. Lots of copies keeps us safe. That works for preservation purposes, but I argue it also works for access purposes. This is actually to the advantage of the journals as well, because if there are multiple copies of your works, not just on your website, that makes it harder for someone to take your work and compete with you for it. Use the non-commercial licenses if you're using CC, and embrace diversity, and I'll talk about some options with alternatives later. Another argument is, okay, well, maybe we can live with ShareAlike. ShareAlike gives us copyleft. That's wrong. Why? Because legally what ShareAlike means is you have to use the same license. The common sense understanding, the way that I would think of ShareAlike is, if I get it for free, I have to share like. Okay, I have to give it away for free too, but that's not true. I can take something that's freely available on the web with a ShareAlike license and put it in my toll access for paid work as long as I use a ShareAlike license. What are the implications for journals and publishers? If you allow blanket commercial rights to anyone downstream, people can take your content the second you put it online and use it to compete with you, or advertising. Maybe you're selling reprints, off-prints. With open access book publishers, often there's a plain vanilla version, a value-added version that people charge for. This could threaten the revenue stream of the journals using the license. My main project, Sustaining the Knowledge Commons, deals with the economics of transition. And I know how hard that is for journals, and if anybody should be making commercial use of this work, it should be the people who've actually contributed to that. Remedy, also some authors are fine with this. Yes, I'm giving away things, anyone can sell it, but not everybody. The remedy here, if you're using CC, use non-commercial licenses. The Research Council's UK has been one of the early leaders in pushing for CC BY through policy. So they gave their universities block grants to pay article processing charges, and they said, if you're using these grants, you have to make the works CC BY license. So they recently did a review, so I'm pulling some of the information from this. And they're acknowledging that some of the comments that they're getting are not just little worries here and there, and it's not just coming from publishers, but scholars like me have principled objections to being required to use CC BY licenses. One that comes through repetitively is, what about third-party content? It's hard enough sometimes to get permission to use this, never mind to use this in works that are going to be CC BY licensed. Even if there are workarounds, you can take a work that is one copyright and put it in another. You see this all the time in newspapers and magazines, a photo courtesy of photographer, all rights reserved. However, if the whole journal, the whole article is CC BY, errors are possible, and so that can be an issue. If you don't allow authors to use this work, even though they could, if the license was more restrictive, that's an academic freedom issue for the authors. Another objection that was raised, this time by the British Sociological Association, is, well, what about sensitive or confidential data? And often those who believe CC BY is the way will simply brush off these concerns. It's just silly fears. People aren't used to the licenses. Once they get used to it, they'll get comfortable. They won't worry about these things anymore. Well, is it a silly fear or is it a serious concern? Here's another lawsuit involving Creative Commons that I think is relevant to this. In Texas, a photographer took a picture of a young girl and posted the picture to Flickr with a CC BY license. Virgin Mobile liked the picture, and so they decided to use it in their advertising campaign with attribution of the photographer, so they were fulfilling the attribution requirements of the license. So far so good, right? Everybody is reusing the work for commercial purposes, getting the work out there. Only problem is the girl and her parents saw the picture and they were not happy, to put it mildly, and there were lawsuits against Creative Commons because the photographer made the point that he didn't understand that this was a possibility that could happen if you use the CC BY license and Virgin Mobile as well. The lawsuit against Creative Commons was dropped relatively early on, and I understand that the case never actually went to court. But here, Larry Lessig, who is one of the other co-founders of Creative Commons with Michael Carroll, blogged about this, and he makes the point that it seems like the non-commercial element is what people really wanted here, and it would have avoided this whole problem. I should acknowledge that this isn't just copyright, that the privacy rights of the minor are actually part of this case. So to go back to the British Sociological Association's concern about sensitive or confidential data, I argue, no, this is not a silly fear at all. It is a serious concern. Many researchers work with human subjects. They give us their photos, their pictures that they've made, their stories, and I believe it is not ethical to release their work under licenses that grant blanket commercial and reuse rights to anybody downstream. I would also argue that for journals or funders who require the license or strongly encourage the license and don't go through people about what these consequences might be, there could be legal issues as well. So in this case, it was Creative Commons, Virgin Mobile that was sued. In future, maybe it will be the Research Council's UK because their policy may have forced an author to use that license. Also, for many of us who are researchers, we're doing research in the public interest. I'm not doing that research so that some unknown person down the line can make a profit off of my work. It is a fundamental conflict with my basic values to require me to use that license. Okay, so that's for commercial use. What about remix, tweak, and build on your work? I'll try to speed things up a little here. That's the remix and tweak, that's in the CC BY license. Reuse, here's reuse. A lovely Flickr picture, thanks to Robbie Reich on Flickr, glowing flowers. Reusing it in this presentation, make it look pretty and make a point at the same time. Here's a remix. Here I'm putting on the Open Access logo, and hooray for Open Access. So there you go. This is a derivative that I might use for Open Access Week. So far so good, right? Well, let's not forget about the moral rights. So far so good, but let's all hope that Robbie Reich likes Open Access and Orange and people putting text on his flower pictures, because if he doesn't, he can come back to me and revoke those rights and maybe even this whole video of this presentation. Scholarly derivatives through remix and tweaking. What a lovely idea, right? Let's be creative. What is a derivative in terms of copyright? Well, some of the common types in creative works are you take a book, turn it into a movie, or you take a movie, turn it into a book, you take a bunch of pictures, put them together and make a collage, a new picture. Music works with mixing different kinds of sounds all the time. Beautiful uses and unleashing that creativity through Creative Commons. A remix, tweaking is wonderful for the Creative Commons. What does this work in scholarship? And this is probably the worst nightmare for authors, would be your downstream co-authored articles. So here on the top, I wrote an article and published it in First Monday. This is a real article in 2013 on the economics of scholarly communication and transition. Well, what would a derivative be? Well, maybe someone downstream decides that they'd like to update and correct my article because Heather came up with some wrong conclusions there. Maybe they publish it in a questionable journal. This kind of use would almost certainly violate the moral rights to integrity of the work of the original author It's clear to me, I'm sure it's clear to the folks at First Monday, but is it wise to assume that this is going to be obvious to any potential downstream co-author and questionable journal out there? I tend to allow derivatives of my own work, but I understand why some authors are reluctant to do this. If you don't want this, why would you grant licenses allowing blank stream derivatives? The Royal Historical Society has made points about that. For alternatives, let's look at specific cases rather than saying blanket reuse. We have lots of work to do just on plain use of works in electronic formats. Reformatting for accessibility, yeah, that's the law, and it's not the Creative Commons law, that's the American with Disabilities Act. If you want to sell your work in the future, you need to deal with this. Private copying and note-taking, it's a lot harder with many electronic works than it was with print. We need to work on that. Data and text mining, if they have problems with their laws in the EU, rather than changing practices everywhere, I would say the EU needs to change their laws. Also that the CC licenses are neither necessary nor sufficient, because when you're doing data and text mining, as your research, you're looking to create new knowledge, a new work, not a derivative. And it's not sufficient because most of the barriers are things like licenses, which have nothing to do with the Creative Commons and could be applied even with Creative Commons licensing. You need to have formats and DRM-free work so that people can actually do the work. Excerpts, I think, are a little bit of a different matter. Can be treated in a different way. Some of this is just fair use. You could be, it's a good thing to make it easier to work with excerpts because there are a lot of barriers to doing works, and I'm sure you know this as publishers, because of the simple difficulty of clearing permissions. Translations, I have mixed feelings about this. Knowledge commons, I want to overcome language barriers, but I work in a bilingual environment. I'm flipping from English and French all the time, and I understand how hard translation is and how much people who work in areas like languages and bilingualism care about their words. Okay, so I understand that some authors are not comfortable with allowing just anybody to make translations. Arguments to be made that remix and tweaking is a long tradition in scholarly publishing. It's what we do. We stand on the shoulders of giants. The typical scholarly article as citation after citation and quotation. We have our own traditions, and rather than trying to fit us into Creative Commons, maybe we should be working within our own traditions, and I think a lot of this is technical rather than licensing work, to make this work even better. But one of the obvious things is let's do way more linking to things like data in archives and to the actual text itself. So some alternatives. There could be different ways that have nothing to do with Creative Commons that might actually work better. This is from a book that was just published called Free Knowledge, Confronting the Commodification of Human Discovery. My chapter is chapter 14. Came out recently by University of Regina Press. There's a free PDF for download where you can buy the book. One of the authors pointed out that they use this copyleft license in another work. So I'll read this out just as one example. It's all rights reserved, but they have this copyright statement you can reproduce without the author's permission, in part or in whole, provided it's distributed and made available for the reader for free without service charges or any other fee. The authors further stipulate that the editors, individual writers, and visual artists all be created for their work. So I think when people use the CC BY ShareAlike license, this is what they're aiming at. I think this language is a lot clearer though. CC allows you to enter metadata for your work, and you can have a more permissions URL. So you could use a more restrictive license, plus a web page that says, okay, well, I'm not giving blanket derivatives, but I'll give some permissions under these terms. For example, maybe you want to allow people to use excerpts such as figures and charts if it's a not-for-profit. But if you're a commercial and you're looking for profits from this, then hey, go to the Copyright Clearance Center, the rights link, and let's talk about payment for this. Maybe you'd like to make these kinds of rights available for free to your members and to your partner organizations, but not for everybody. Sharing commons, this is from Leslie's post. I agree with it. It fits with my idea of the knowledge commons. A sharing commons, not a commercial commons. Let's embrace non-commercial licenses. An experiment. One of my favorite approaches is First Monday. They give the author the right to retain copyright and choose our own license. That leaves you out of the hook legally because the author can choose any of the Creative Commons licenses, all rights reserved, whatever they want to do. In the long term, I argue that we need to be arguing for fair and balanced copyright everywhere around the globe. We're nowhere near this, and we have a battle to keep even what we have because the copyright discussions have moved from the World Intellectual Property Organization into trade treaty discussions like the Trans-Pacific Partnerships. And so we're going to have to struggle for good copyright anyways. To make it a norm, if it's free on the web and the copyright holder did not say there's these restrictions on it, certain things that you can do, read, qual, copy, redistribute for non-commercial purposes with attribution. For preservation and ongoing access, I see that as being public archives and libraries and not necessarily the responsibility of journalism. So just to conclude, and I am a researcher, so a little bit of self-interest here as well, that I don't think we should just assume CC BY is the way to go, but we need to do some research, and this includes analysis. So what are the potential uses and reuses, and what are the best ways to get there? Maybe it's licensing, maybe it's technical, maybe it's metadata. For example, text mining humanities, let's talk to the scholars who are either doing this or want to do this, find out what do they want to do, and what are the barriers and how can you overcome them. I haven't had time to really look at and think about the moral rights in CC BY licenses, which actually are in the US over and above automatic copyright. Now, being from Canada, Canada is one of the countries which has a tradition of strong moral rights in copyright. There's a little true story. If you're thinking moral rights and copyright and strengthening these is a good idea, it was about a decade ago, a department store in Canada called Eaton's had commissioned a sculpture of some geese. And then it was Christmas, and I thought it would be fun to hang some scarves on the geese. And the artist sued the department store for violating their moral rights as an author, and the artist won. So do we want, are the stronger moral rights with CC licenses necessarily in the best interest of scholarly works and moral rights to academic freedom? I'm not sure, I just would like to raise that question. Facilitating translation, rather than just saying anyone can translate, why don't we talk to people who do translation, to subject experts and licensing experts to see how can we do this without invoking some of the dangers that some people are concerned with. So that is all for me, and I look forward to the questions and answers and to further discussions on it.